Hi, this is Rajeshkumar. Today we are going to analyze one problem question on unilateral contract. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. The problem question. The Royal Arch Club is holding a race. It displays a large notice at its premises. The RYC will hold a arch race at 10 a.m. on 1st of April. A prize of £5,000 has been deposited with our bank to be paid to the winner. Advise the club about any liability it may occur in the following alternative circumstances. The scenario A at 9 a.m. on 1st April, A is on the board, had arch, and about to set out for the starting line. When he hears over the radio a conversation between two other yachts that the race has been cancelled. She is annoyed as she bought a new set of sails especially for this race. Scenario B. B is leading the race and approaching the finishing line when the club commodore, an official of the RYC, tell him that the race has been abandoned. The club commodore does not like B, who he thinks drink too much wine. Scenario C, same scenario as B, but the prize offered was £50,000. Scenario D, Cheat is approaching the finishing line just behind Dirk. Cheat starts his engine, which is forbidden by the race rules, and crosses the finish line and ahead of the Dirk. This question involves a unilateral contract which arises when one party, the offerer, makes a promise that is accepted by the performance of the requested act by another party, that is, offeree. The case of Carlyle versus Carbolic Smoke Bulb case, 1893, established that such contracts are formed when the act is completed and acceptance does not require communication. The Royal Arch Club offers to pay £5,000 to the winner of yacht race, creates a unilateral contract, but certain events have raised issues regarding the potential revocation of this offer and the club's liability. In other words, then the notice from the ROC about the raise and the price resembles an open offer to all eligible participants. It is much like the Carlyle case. By beginning the preparations or participating, competitors would be accepting the terms of the offer, creating a unilateral contract. A revocation of a unilateral offer can be complex, as in Shui versus United States provides that the revocation should be communicated in the same manner as the offer, in this case, through a formal notice to competitors. Let's start with the scenario A, where A is the claim, the cancellation not communicated to all, where the ROC, the unilateral contract, was breached by cancelling the race without formal notice to all the participants, causing A to incur expenses on the assumption that race would proceed. The A's preparation and purchase of the sale imply her reliance on the offer of a price. In Errington versus Errington case, the court held that an individual completing the conditions of the unilateral offer creates a binding contract by preparing for the race. A may have initiated acceptance of the offer. The cancellation was not communicated directly by RYC but overheard on the radio. Following Shea versus the United States, the revocation of unilateral offer must be communicated in the same manner it was advertised, ideally posted at RYC premises or sent to participants directly. Without these, A could argue that revocation was ineffective. RVC may be liable to A for the cost of her new sales as she incurred this expense based on the reasonable assumption that the race would proceed. In other words, in unilateral contracts, once the offeree begins performance, the offerer generally cannot revoke the offer. The principle was established in Errington versus Errington case 1952, where the court held that revocation was not allowed once performance had commenced, unless there was a term allowing revocation at that point. However, for revocation to be valid, it must be communicated to the offeree by the same or more effective method as the original offer, as per Shui versus US in 1875. If the club relied on indirect communication through the third parties, that is, via the radio, the effectiveness of the revocation could be questioned unless it was recognized means of communication. Since A was about to start the race, but had not yet begun, she had not commenced the act of performance required to complete the acceptance. Therefore, the club may be able to argue that the contract was not fully formed, and thus it had the right to revoke the offer. However, her reliance on the offer, particularly the investment in new sales, might give rise to the claim for detrimental reliance under promissory estoppel principle. The scenario 2, B's claim, raise abandoned due to the dislike. The abandonment of the raise by Commodore. B is leading the race when the Commodore tells him that the race has been abandoned. B was nearing the finish line, and the Commodore decision seems to be motivated by personal dislike. In Jollier Limited versus 4 Millbank Nominees Limited in 1978, the court held that the unilateral contracts, the offerer cannot revoke the offer once the offeree has begun the performance. Since B was leading the race and nearing the finishing line, he had substantially performed the act required to win the pace. The Commodore's principal motives for abandoning the race might constitute an unlawful interference with B's performance, and the RYC could be liable for the breach of the contract. The B's near completion of the race likely create a binding unilateral contract, and thus he would be entitled to the prize unless there was a valid reason for abandonment. In other words, a B was close to fulfilling the condition by nearing the finish line. In Dahlia versus 4 Millbank Nominees Limited, once an individual begins to perform the conditions, the offerer cannot prevent completion arbitrarily. Hence, always is obliged to allow the race to proceed fairly. Revoking the offer arbitrarily, especially when the race conditions were almost completed, could amount to an unfair breach. Based on the Dickinson versus Dodds, once B began the performance, RYC's cancellation must be for the valid reason, not the personal biases. The potential liability. The RYC could be liable to the B for his efforts in preparing and participating in the race. An arbitrary decision to cancel as based on the personal dislike is not a valid revocation. The scenario C, a B's claim is a 50,000 prize. The prize in this scenario is 50,000, a much large amount, which raises additional concern about the revocation of the offer. The Luxor principles and the large price. The Luxor, Eastbourne Limited versus Cooper in 1941, the House of Lords held that a large rewards for a small amount of work could allow the offerer to revoke the offer even after performance has begun. In this case, the court considered that the offerer's liability might be too burdensome relative to the work performed by the offeree. However, B had nearly completed the race, meaning he had already undertaken significant effort. The size of the prize could create concern about unjust enrichment if B is allowed to claim such a substantial sum for, a, for an incomplete race. Nonetheless, given that B was close to the completing performance, it would be difficult for RYC to justify a revocation without offering some form of compensation for his efforts. The high price value reinforces the gravity of ROC commitment to the race. The court in Luxo versus Cooper held that high stakes and substantial reliance heighten the obligation to perform or maintain the contract's condition. Here, a 50,000 prize means participants likely invested considerable time and resources reinforcing ROC responsibility. Canceling a race with a 50,000 prize without a justifiable cause imposes a higher duty on RYC to ensure a fair competition. Revocation at this stage might be viewed as acting in bad faith or breaching the implied contract, especially when B was nearing the finish. ROC could be liable for significant damage due to B's reliance on the contract, which courts potentially awarding a portion of the price or damages for the lost opportunity. Uh, comes to the loss scenario, D's claim against cheat. A cheat uses his engine, which is against the race rules, to overtake D and crosses the finish line first. A cheat action violates the race rules, which likely formed part of the terms of the contract. In Corley's case, the court held that performance of the act must comply with the terms specified in the offer. Since C breached the race conditions, he would be disqualified and the unilateral contract would not be fulfilled on his part. As a result, the ROC would not be liable to pay the cheat the prize money, and D, the legitimate second place finisher, might have grounds to claim the prize. In other words, a term in ROC notice implied that compliance with the race rules was necessary to win the prize. By starting his engine, Cheat violated these terms, effectively disqualifying himself. According to Carlyle, any deviation from the stated terms nullify the claims to the prize. In Errington versus Errington case, the fair enforcement of condition was emphasized as integral to the contract performance. ROC must ensure fair play as non-enforcement could expose it to claims from other competitors like Dirk, who abided by the rules. ROC could be liable to Dirk, the legitimate winner, for failing to disqualify the cheat. Dirk has a potential claim to the prize based on his adherence to the rules, as he was technically the first eligible finisher. Let's conclude. The ROC liability is likely limited in A due to the insufficient revocation. As in the scenario B and C, B would be entitled to the prize given that ROC abandonment does not constitute a lawful revocation of post commencement. In the scenario D, ROC is not liable to cheat due to his breach of the competition rules. Hence, the opposite case, the club revocation may be valid as she had not started the performance, but her reliance may still give rise to a claim. In this scenario two, a B's case, once he began the performance and near the completion, the club would likely be liable for the breach if it cancelled the race without the just cause. And the scenario C, the 50,000 pound scenario, although the price size might raise concern about revocation, a B's substantial performance make it difficult for RYC to escape the liability, and the cheat breach of the rules disqualify him from claiming the prize under the terms of the contract. Thank you.